welcome to Harassment and Bullying Prevention. This is Session B. This presentation is by Prevent Harassment, dedicated to ensuring a workplace free of harassment and bullying. Your organization has a 2-hour required training. Session A was provided by the state of New York, and to be consistent across multi-state operations, we ask that you take Session B. Session B will cover more about the practical issues from a manager's perspective, what to say, what to do, how to behave and interact with your staff in order to prevent harassment. With regard to the practical issues, you need to know your rights and responsibilities and also the resources that are available to you to support you as a manager, supervisor, or team leader. In this section, we'll talk about the practical issues impacting you as a supervisor or manager. First of all, we'll talk about how to respond to a complaint. Then we'll discuss how to avoid retaliation, how to avoid discrimination and harassment in your day-to-day interactions, and then finally, how to ensure consistency and fairness in all of your employment decisions. How to respond to a complaint. Here are the tips you'll want to keep in mind to avoid liability. In terms of responding to a complaint, if an employee comes forward with an issue, problem, concern, question, or observation, you want to make sure that you're taking the situation seriously. One of the first things you want to say is thank you. Thank the employee for coming forward with this information and for taking the situation seriously. A good rule of thumb is that you want to be empathetic, not necessarily sympathetic. You can certainly tell them that you appreciate what they're going through, but don't add fuel to the fire by making it worse and feeling sorry for them and being overly sympathetic. Also, you should certainly not do an investigation yourself. An investigation is a term or condition of employment that is best handled by trained HR professionals, attorneys, or investigators. Once you have a sense of the facts, then you can decide if you can handle this situation because you have the skill and the confidence to do so, or if it contains a legal issue and you don't feel comfortable handling the situation on your own, you want to probably refer it to an appropriate person. The most likely person is usually an HR or employee relations person. Now, there's a lot of good reasons to take the initial complaint and give it directly to your HR person, and we'll talk about why. One of the main reasons is to maintain confidentiality. You obviously can't promise complete confidentiality, but you can let the person know that their confidentiality will be respected at the extent possible. And information regarding the complaint will only be shared with someone who has a demonstrated need to know. Giving the complaint to HR also helps to maintain consistency. As mentioned before, an investigation is a term or condition of employment, and it's hard to be consistent across the board with all managers and supervisors. But if only a few key people are handling investigations, we can maintain consistency in our organization. Another good reason is that this provides help later to defend the organization in case there's an issue that's brought up. Documentation, rosters, paperwork, and investigation notes all help the organization to demonstrate the concept of reasonable care for the affirmative defense, as we had discussed in Section A. Also, giving the complaint to HR helps get you out of the loop, and that's important in terms of maintaining your objectivity as a manager, supervisor, or team leader. It will also help limit your personal liability, which we'll talk about in a moment. Those are all very good reasons to refer the complaint to Human Resources. To respond to a complaint, first of all, you want to say thank you to the employee, and then just say something to the effect of, I understand your concern, your question, or your complaint. Then let them know the process that you're going to follow in terms of referring this complaint to Human Resources or whatever your decision is going to be to follow through on the complaint. Let the employee know that you can't promise confidentiality, as we discussed previously, but you'll only share the information with someone who has a demonstrated need to know. Then follow up with Human Resources and the complainant. Then, my suggestion is to send a quick email to your HR representative and let them know that you have an issue you'd like to discuss with them. That way you timestamp the complaint and you can demonstrate that you took prompt action on the complaint. Then you can discuss the details over the phone or in person. And certainly don't treat the employee any differently while this complaint is being resolved. That could be an example of retaliation, possibly. Let's talk a bit about avoiding retaliation. Retaliation requires 3 elements. The first element is a protected activity. Examples would be an employee coming forward with a complaint or being called upon as a witness in a situation. The employee is protected from any adverse action. The second element is an adverse employment action. Those actions could be either concrete or subtle. Examples of concrete adverse employment actions would be job loss, demotion, loss of pay, failure to hire, or failure to promote, those sorts of things. And subtle examples are ignoring an employee, ostracizing an employee, not continuing to meet with them on a regular basis, or leaving them out of company events, those sorts of things. Now, if a connection can be shown between the protected activity and the adverse employment action, that is enough to demonstrate retaliation. And having retaliation involved in discrimination and harassment complaints makes it all the more difficult to defend the organization. To avoid retaliation, first of all, you want to be respectful of the employee's rights to complain. We do want employees to come forward with information that will help us do a better job of ensuring good employee relations and conflict resolution. And so you definitely want to be respectful in that regard. By treating each and every complaint seriously, we demonstrate that we do take the issue of harassment and discrimination prevention seriously. So take the complaint and follow through on the investigation procedure as we've discussed previously. Avoid any assumptions or preconceptions you might have about the employee, and treat the complaint with an open mind. And certainly seek guidance from your manager or human resources on all the decisions you make about how to handle complaints. Remember, you have a lot of internal resources to assist you in handling the initial complaint. And of course, it's worth reinforcing the idea that you want to maintain confidentiality throughout this process and only share information about it with someone who has a demonstrated need to know. And when we talk about confidentiality, we mean verbal as well as written records that you might obtain through this process. So be careful with both verbal and written information. As an employee of the organization, you obviously have certain rights, but also responsibilities. One of your responsibilities should be to read the policy and make sure that your staff reads the policy as well. Employees should also uphold the standards outlined in your employee handbook or policy manual. And finally, employees should follow the complaint handling procedure as outlined in the policy. That's very important. Some of the responsibility of supervisors and managers is to step in case they observe behavior that is not up to standard. That requires you as a team leader, supervisor, or manager to remind other people about the policy in case you observe or overhear issues that might be problematic. We can't necessarily require employees to step in case they see an issue of concern. However, they should feel comfortable bringing it to your attention. And if you're aware or you observe or hear about a situation that is of concern, you definitely need to step in. An employee should also know about the complaint handling procedure and follow it. They have multiple avenues of complaint available to them, such as a supervisor, manager, or anyone in HR or any senior manager. And so they should feel comfortable coming forward with any complaint or observation. We certainly want employees to speak up if they know or suspect a situation, so we can be aware of it and resolve it appropriately. There are several reasons an employee wouldn't want to get involved. Number one, they wouldn't want to appear as if they were reporting on their friends or coworkers. Number two, perhaps they just don't really want to be named in any sort of complaint themselves. And then number three, they might fear retaliation, which is obviously a huge concern to us. However, it is an employee's responsibility to come forward if they have any concern themselves. How to ensure fairness and consistency. As a manager, you have a higher level of responsibility to do what's right, and these issues can come up in every step along the way of the employment relationship. For example, in recruitment, we want to make sure that we are fair and consistent in everything that we do, from sourcing to screening to interviewing. With interviewing, we want to avoid questions that are unlawful, such as, are you married? Are you a U.S. citizen? When did you graduate from high school? Although it is okay to ask about graduation dates from college. You can also not ask about past salary or any criminal background questions. Basically, any part of the recruitment practice has to be fair, consistent, and systematic. That includes testing, background checks, I-9 verifications, which of course the Human Resources Department would do, any credit checks or background checks, those all have to be systematic. Any other hiring practice that we would engage with also has to be fair, consistent, and mindful of all the legal restrictions in terms of pre-employment inquiries. We also have to be fair and consistent in any decisions we make about day-to-day management issues, such as compensation. There are several issues having to do with equal pay for equal work, and our compensation practices have to reflect that. This would also have to do with any assignments that we give to staff, ensuring that all the tasks and projects we assign are assigned fairly and consistently, and having to do with skill or seniority or experience, but not having to do with any other arbitrary factors that might be a legal issue. Transfer decisions, of course, have to be fair and consistent and focused on job-related issues. As long as we make decisions based on job-related factors, we'll be fine. So get guidance from your HR representative or your manager whenever you make decisions about your employees. Promotional decisions obviously have to be reflective of experience, performance, those sorts of factors, and not related to arbitrary factors such as their race, religion, national origin, ethnicity, or age. Also, consider training opportunities such as management development courses or attendance at a conference. Those sorts of activities are all opportunities that should be open to all of your employees, not necessarily based on any personal preferences that you might have about them. Regarding training opportunities, it's important for managers to consider the career development opportunities of their staff. So talk to HR and your manager and make sure that you are working with employees on their training and development plans. With regard to leaves of absence, those are most likely done by a specific person in your human resources or benefits department, and all leaves of absence should be done consistently and fairly. Leaves of absence could be for pregnancy leave, family leave, jury duty leave, or military leave, and all of those leaves would follow the same process in terms of paperwork and documentation. We also have to ensure fairness in performance management. That would include performance evaluation process, any corrective action or performance improvement plans you might put in place. Certainly any decisions regarding layoffs or terminations should be done in concurrence with human resources. And also you have to make sure that you're fair about applying your policy of providing references. Check with your manager or HR to confirm your policy regarding providing references. As we've seen, basically every term or condition of employment is subject to the general rule of fairness and consistency. That way we can avoid comments about unfairness or possible discrimination. If you have any question regarding your decisions, check with Human Resources or your manager to ensure that you get their stamp of approval on any decisions that you make. The next topic is how to avoid being a target of a harassment complaint yourself. Oftentimes, supervisors and managers are blamed for various actions in the workplace. To avoid being a target of a harassment complaint, make sure that you're conducting yourself in a professional manner at all times. Never joke or belittle employees and coworkers, and certainly if you hear someone else joking about an employee or making disparaging remarks, you should step in, so you're setting the stage for appropriate professional interactions. If you continually do that, You'll have a reputation of being a very professional manager. Next, it goes without saying that you should not date your employees. Your employees may date each other, but certainly employees shouldn't be dating if they're in a supervisory subordinate relationship. There are a lot of risks associated with dating in the workplace. A romance could go sour that impacts and creates conflict in the workplace, which is not appropriate. You may consider the importance of maintaining a separate social life. Of course, you can socialize with your staff, but when you do, make sure that your behavior is 100% above board. This would apply to any company parties or sporting events, conferences, off-site dinners, those sorts of activities. Just be conscious of your conduct at all times with employees. Employees typically look to their supervisor or manager to set the behavioral standards. And as we've talked about before, it's very important for you to be a good role model with your staff. We want all the relationships in the workplace to be smooth. And we also want to avoid potential legal issues. So 100% of the time that you're with employees, you need to be conscious of your conduct. Finally, treat all employees respectfully. Treat employees the way you would want to be treated. And if you do that, you should have a good reputation with your staff and with other people within the organization. And that will help you to avoid being a target of a harassment complaint or have any employee complain about your conduct, whether it's off-site or on the job. To summarize this section, we want to make sure that you understand that managers, supervisors, and team leaders have higher standards. You have to know your resources, and that would include the policy manual or employee handbook that you have, but would also include the internal resources that you have available to you to answer any questions that you might have. That would be human resources, benefits, or your manager would provide you answers to any questions that you might have. Now, we've reached the middle of the session, and as we mentioned before, on the certification test, there will be a code that's needed. So you probably want to write this down. And the code is CNYXR. After you finish watching this video, you can take the second certification test for Session B. Now let's move into case examples so you can understand how the legal issues are applied in various case decisions. These case examples demonstrate legal issues that can arise from problems with mismanagement of employee complaints. This first case involves Braun Electric. They were directed to pay $82,500 to settle a sexual harassment lawsuit filed by the EEOC. According to the lawsuit, since 2010, a male manager continually subjected his female coworkers to harassment and a hostile work environment. Some of the manager's unlawful behaviors included grotesque sexual remarks and explicit sexual propositions. Here's a case involving national origin and age harassment, involving a San Jose employer. It was a security firm who failed to stop coworker harassment of a guard concerning his national origin and age. The guard worked for an organization called Guardsmark, and he faced constant workplace harassment regarding his national origin and age. He was 66 at the time. Examples of the workplace harassment include a coworker who repeatedly ridiculed him and his clothing and accent. The same coworker made comments about his age, and the supervisor ignored his complaints, taking no action to address the hostile working conditions. He was then involuntarily transferred, leading to a reduction of his hours and a loss of employee benefits. The lawsuit was settled with the EEOC for $25,000, as well as further remediation, such as displaying the poster and conducting harassment training. Another case involved a $40,000 settlement for national origin harassment and retaliation. This case involved a family-owned bakery who violated federal law when the principal owner harassed an employee by verbally abusing her with offensive ethnic and racial slurs. The manager made generalizations and used racial epithets. The bakery then tried to force the employee to accept a layoff and then wrongfully terminated her when she refused. The bakery then retaliated against her by suing after she filed a lawsuit with the EEOC. The bakery was ordered to pay the plaintiff $40,000 and take steps to prevent future discrimination. This case involved a transportation service who was sued for race harassment. The company was sued for race harassment when the trucking company allowed a supervisor to harass truck drivers with racial slurs. The driver was targeted by his dispatcher with racially charged comments. The employee alleges that he also heard other racial slurs directed at various ethnic groups. In addition to that, other employees witnessed workplace harassment and even complained to management. However, the company failed to take action against the supervisor, so the race harassment continued. The company will pay the plaintiff $30,000 and provide annual anti-harassment training for all employees. Another case illustrates national origin and religious harassment. The company was found to have violated federal law when it allowed supervisors and coworkers to harass and discriminate against an employee. The employee was from the Middle East and he faced workplace harassment, both verbal and physical. He was called nicknames and subjected to racial comments and physically harassed as well. The company failed to take action even though he repeatedly reported the harassment to employers. So those were just a few examples of ways that an employer can be challenged for harassment and discrimination, as well as retaliation. Note that those cases involve various protected categories: age discrimination, national origin discrimination, as well as sexual harassment. Effective October 11, 2019, the New York Human Rights Law now explicitly includes protection in employment from harassment based on any protected class. Here's a list of all the protected classes in the state of New York: age, creed, disability, domestic violence victim status, gender identity or expression, familial status, marital status, military status, national origin, predisposing genetic characteristics, pregnancy-related condition, prior arrest or conviction record, race or color, sex, sexual orientation, or retaliation for opposing unlawful discriminatory practices. Also note that one more protected category exists under the human rights law, which is a lawful source of income, but this is in housing discrimination only. Also, on August 12, 2019, Governor Cuomo signed legislation that strengthened protections against discrimination and harassment, including sexual harassment, under the New York State Human Rights Law. The legislation strengthened New York's anti-discrimination laws to ensure that employees can seek justice and perpetrators will be held accountable by eliminating the restriction that harassment be severe or pervasive in order to be legally actionable. The law also mandates that all non-disclosure agreements allow employees to file a complaint of harassment or discrimination and extends the statute of limitations for employment sexual harassment claims from 1 year to 3 years. A complete list of the new provisions can be found at www.dhr.newyork.gov or on a link under Resources at uspreventharassment.com. In summary, we want to make sure that you and your staff behave in an appropriate professional manner at all times, so you don't encounter issues like the ones that we've just talked about. You also have to respond appropriately if an issue comes up. So know your responsibilities as a manager or supervisor and behave accordingly. In order to ensure that you comprehend all the material in this training class, we have a couple of different final activities for you to complete. The first activity from session A is to review the set of posters that we mentioned in the first session. And those posters are hanging in the workplace in an area that's frequented by employees. So presumably it's in the break room, the supply room, or in the HR department. For session B, we want you to review your policy manual, which is either in a hard copy form or on your intranet or a shared drive. And that policy would specifically look at the EEO policy, the sexual harassment policy, and the complaint handling procedure, so you can be certain what your role is in handling any complaints that may arise. Now you're ready for the second certification test. Like the first test, there's 10 multiple choice questions, and you need to receive a score of 80% or higher. You'll also need codes for the middle of the session, as well as this code for the end of the session, and that code is CNYWR. You'll receive a certificate for each session that you take, both A and B, and your employer will receive a copy of the information as well. Some states require a 2-hour training session. Session A with the video, the activity, and the test equal 1 hour, and Session B with the video, activity, and the test equals another hour. So that fulfills the 2-hour requirement. So thank you, and congratulations for completing the training. Remember, your role as a manager, supervisor, or team leader requires that you be a good role model, so we appreciate you taking this topic seriously. If you ever have any questions about the content of this training, you can reach us at the website, which is uspreventharassment.com. Thank you very much, and we look forward to hearing from you again.